I had filed 439, but it should be appeal relies in rejection of the order of the CCL court, children court. So I want to withdraw this petition.
Section 101 of
100 of 1, yes.
subsection 5.
And my lordship,
My lord, I am ready, my lord. I have made a note
My
also.
lordship,
That will be
I had gone through
There must be a
I
hearing,
had
my
gone
lord.
through the Delhi High Court judgment. Section 12 application can be filed in section 12, but I will file appeal. I want to withdraw this petition, liberty to file fresh.
Have you seen my judgment?
Definitely, sir. Yesterday you said me,
I
so
was
that
gonna
is stuck
take
in my mind.
that.
I have learned one best thing.
I have, you have seen one judgment of mine on that?
Circuit bench matter. This,
No,
the next one.
the another one on this is score. You have not.
Not so.
Go through that judgment. I think sitting with Justice Subhashish Das Gupta.
Sure, sir.
The question arose that I was the person instrumental of raising that question, because yesterday you have seen that I raised certain questions.
Definitely, sir. That is
So I also raised a question whether a juvenile is entitled to anticipatory bail.
yes.
Whether he is entitled, because section 12 has to be interpreted in that line.
Yes.
And whether the juvenile, then I referred various judgments and I arrived that why not? Why not? He is entitled to anticipatory bail. But the another coordinate division bench subsequently has dissented, and the matter is referred to a larger bench. I do not know whether that has been
Till now, it is not.
My lordship, there is a conflict, definitely, but I want
So-
relief. That's why.
so that's why I said that whether you can. Now this is 439.
My lordship, I can't, I
In view
cannot,
of-
because
in view of section 12.
specific judgments of Supreme
Lord,
Court and
yes,
Delhi High
let
Court.
me do a lot of homework at up to 3 today morning. I have done all this homework, my lord, all this research on this, my lord. There must be a hearing. It's my prayer. I've
My
got a
lordship,
note also.
my lordship, this
I'll
is my
share the notes with him.
This is my application.
No, even then,
I'm
when you
quite
have put up the matter, when
I'm-
you have mentioned the matter and the state is ready,
And my
it
lordship,
should be heard.
I am having ample judgments.
If you want to withdraw, it
In
has
my
to be
bag.
withdrawn at the first instance, not after 2 days.
Then I remind you of the judgment of the Supreme Court is Rashmi Metallic.
Rashmi.
You just read, I believe, paragraphs 5 or 7.
Surely,
Read that.
surely.
You read that particular paragraph.
Surely, sir.
When you took out something from your bag. So for that purpose, the Rashmi Metallic has to be seen.
Sure, sir. Sure, sir.
But I have shared regarding the views of another high court, 3 high courts, Uttarakhand, on Chhattisgarh and on UP. I have 2 citations.
My lordship,
Due to
I am
lack of time,
withdrawing
I
this
could not-
matter.
He's withdrawing it.
I am withdrawing. This is my application.
My lord,
I am withdrawing.
withdrawing, but
Item
let's make a hearing, my
184.
lord. If you want, actually the
All right.
provision is very clear.
No. I understand it. That's why I said that there are issues in this regard. And the issues is yet to be settled.
Yes, sir.
So that was a 438, not 439.
This is 430. That was
That is what
438.
438. That's why I said.
Tried my best in that case, but it was against the state.
So
It
you
was
will get a
here
chance.
or- It was here.
Yes, my lord. It was online. I was.
No. Circuit bench matter.
Yes, my lord.
I don't think so.
বিশ্বাস, Rima, they were on the
No,
other side.
no.
You said, my lord, the verdict, it was the judgment was.
Mr. Shekhar Bose was appointed as amicus curiae.
That man.
No. Anyhow, you want to withdraw, why
Yes,
you
sir.
put,
My only request, my lord, only for academic, my lord, I have made a.
Sir,
note,
this
my
is
lord.
my
Please
application.
go.
This is my application. I want to withdraw it.
no, what
Sir,
he
it's
wanted.
my request.
No, what he wanted, that there should be an academic discussion on that and let there be a law declared what to it. That is what he wanted.
Definitely.
Nothing more than that.
All right. Sir.
Ultimately, will you withdraw or not? That is up to you.
All right. Sir.
No difficulty.
All right. Sir.
Why? He's withdrawing.
It's a very interesting point.
I know, but
Sir, again,
My lord is all well acquainted with the law. On the last occasion, my lord has done a lot of research. My lord can
Yeah.
pass a very sound order in this case, my lord. Let it be a CAV, my lord, that will be kept.
You have seen my principle that I never carry any matter to a principal seat and deliver a judgment. No, till date, not a single.
Yes,
My principle is that if I have heard here, I will deliver a
Right.
judgment here.
yes.
The views of the other division bench is also there. One citation of
So,
the division bench.
so I don't carry it.
Sure.
Only thing is you will burden me with this.
Yes.
But it is a question of law, my lord.
No, no, that's
Section
true.
101, only interference of the High Court.
Just wait, let us frame the mind.
And sir, once
worry.
again, I want to mention, this is a duty of the public prosecutor. They need to prepare for all the matters, But for my compulsion, I came to know that I want to withdraw this petition.
No, no, I
All
understand.
right.
I understand.
Withdraw first instance.
Yes, I
When the matter was called for.
Anyhow, don't worry.
There was
Subject to-
emergent-
Anyhow, let us see.
Not
Yes,
subject
Paul.
to Lordship's kind sanction with regard to item number 198.
What?
The bail application, my lord, if
No, we are taking up last week, we did not work. I think 2 whole day was spoiled. Nobody appeared for the, for any matter, in any matter.
but today, my
From
lord,
the bar.
if your lordship can take.
No, we can't assure you. Every bail application is very important for us. Giving a precedence to one matter because you travel from Calcutta and
No, no, my lord, I
appear.
cannot say that.
No, that will be an unrich, I would say, overrich on the other litigants. No, we don't. Every litigant is equal enough before us. Let us see. Yes, call.
My lord, one indulgence, lordship. With respect to my lord, item number 246 in today's list. Lord, your lordship has heard this matter on Friday as item number 266 and directed the matter to be taken up today.
Let us see.
So, my lord,
Let us see.
one difficulty is, my lord, the trial court has fixed the date today with respect to, my lord, the cancellation of bail application.
Yes.
My lord, unless your lordship passes, my lord, some protection, my lord,
No, let us see. Let us see first. It's a 266.
246 in today's list.
240.
Well,
Then
at
let
the
us see.
DNA
Let us see.
test
Let us see which we can reach. Don't worry.
My lord, any time today.
Let us see. Let us see. For ceremonial purpose. Nothing. No, mention before the other circuit bench. No, it can't be. Let us see. Yes. What is this correction? রাখবো এখন, কিচ্ছু করার জন্য। What name? I do not find any name. Abhijit Sarkar for whom?
State Council, Lordship.
And who, where is Aditi Shankar Chakravarti? So his name is there,
Actually, I moved before your lordship.
not he.
No, my-
So his name to be deleted.
yes, your lordship, my name.
So his name is to be deleted. Delete it.
Yes,
Delete.
your lordship. Ah, it-
No. Yeah, I will delete that name. Let's call the next.
For the petitioner, my lord. My lord, on yesterday, the lordship was partly heard the matter and asked the,
Was partly heard the matter.
so, my lord, partly heard. My lord, case was initiated at 305. And the opposite party number 1 and 2 got the privilege of anticipatory bail. Subsequently, but 2 and 3. Subsequently, they created torture upon the de facto complainant. The lordship was pleased to ask the learned PP to produce the case diary of the next case.
And the case diary, I am holding it, my lord. And regarding the 307 indicated, this is the injury report.
The injury report is immaterial in this case.
Huh? Very interesting argument.
Lord,
At the time of bail, the injury report is
No, no,
inconsequential. Very interesting argument.
it is a cancellation of bail, my lord. It is a matter of cancellation of bail.
But the injury might is what exactly happened at that relevant point of time. Why it was allowed, the bail application was allowed.
One indulgence I am seeking. It is a cancellation of bail matter.
I understand, sir. There is another case which is also registered for the.
In that case, they got the privilege of anticipatory bail. They
Correct.
assaulted me and I have lodged a complaint and a case was initiated and they were arrested. So to some extent, my little understanding is concerned. It is a crystal clear that they tried to assault me and created pressure upon me to withdraw the earlier case.
This is a case of a given a possibility to go over the telephone and then the girl connected to the family. It's a clear case of a society. Questionnaire, investigation that you instigated a girl to that extent to commit a suicide. So it is all dependent on the circumstances and to the nature of the quality of relevant treatment. Direct evidence sufficient or any regulation in the cases. Then nothing is proven. Yes. Where is the order granting bail?
My lord, page number 11, my lord. They have, so far my little understanding is concerned, my lord, they have violated the.
No, that was granted by the court session judge.
And after getting the privilege of anticipatory bail, they created pressure upon me.
Correct. That's why we called upon this particular case diet. And where is the other any recording of the statement of any persons witnesses under 161
Under
in the
161,
other
my lord,
case?
Page 7, 8 and 9, my lord, 161.
Yes.
One indulgence I am seeking, my lord.
Consider one thing also. You will not be within the peripheral of say 40 meters or 100 meters around the house of. Should not come.
Same number is there.
Ensure that it does not come within 100 meters of his residence. Nothing has come out, sir. The statement of those witnesses have said that there was a grievous injury which was inflicted upon you. And medical report says nothing.
What?
I understand the agony. I understand because you have lost your
I
daughter.
have lost my minor due to their.
Whatever, lost your daughter, minor or a major, it's a daughter is a daughter. Is a daughter.
Lordship,
I can
one is-
understand the agony, anguish which is there. You wanted a justice to be done. We'll definitely ensure that the justice is paramount. And therefore, everything is to be done. They will not come within that. And
Within the
peripheral of 100 meters, 100 meters.
But actually, for the purpose of employment, I have go elsewhere. And again, I may be assaulted by them.
Why they will be? Ensure that
They have the right of filing an FIR.
No, that is fact. But how many times I will lodge a FIR to protect myself?
no, you can continue multiple FIR, you can continue
not my intention, my-
provided the incident happens. Come. This is an application for cancellation of bail granted by the session judge, Jalpaiguri, within bracket in charge, on 12th December 2023 in criminal miscellaneous case number 2160 of 2023. On the premise that after the registration of the case and the accused being released on bail in the trial court, they have created an undue pressure and even inflicted assault on the petitioner and his family members in order to create a pressure to withdraw the instant case. On the basis of the subsequent complaint lodged by the petitioner, a case was registered against the respondents herein, and we directed the state to produce the case diary of the subsequent case. We have gone through the statement of the witnesses recorded under section 161 of the CRPC in connection with the Malbajar PS case number 1022 of 2023, registered on 17/12/2023 under section 341/307/506/34 IPC, and does not find that and such and such, and we feel that if the order granting bail is modified to an extent to ensure the safety of the de facto complainants of the instant case, the same would subserve the justice. Furthermore, after perusing the facts discerned from the FIR registered in connection with the instant case, the trial court was of the view that the custodial interrogation of the respondents are not necessary. So, charge sheet has been filed in this case. It further discerned from the record that the minor girl of the petitioner committed suicide. Yes, committed suicide.
5 case, charge sheet has not been submitted.
Subsequent case, that is subsequent.
In this case, it has not been. It's committed suicide, and suicide after a long conversation over the telephone with the respondents. Obviously, it is a case of now. Obviously, obviously, the case is required to be tried on the basis of evidence to be adduced in this regard. And therefore, we do not find any infirmity in the order of the session judge in charge, Jalpaiguri. Considering the fact that the petitioner alleges interference and or intimidation by creating a pressure to withdraw the aforesaid, to withdraw the said aforesaid case, we feel that the respondent should not be permitted to enter a space surrounding the residence of the petitioner up to 100 meters. And the police authority shall ensure the strict compliance in this regard. The counsel for the respondent assures this court that his client do not violate such conditions, nor ever violated the same. And the subsequent case has been initiated in order to create pressure upon the prosecution. So be that as it may, we do not venture to enter into the aforesaid aspect, and therefore modified the order of the session judge to the extent that the respondent shall not enter within 100 meters surrounding the house of the petitioner until the disposal of the case. With these observations, the application is disposed of, no order as to cause.
My lord, with item number 3, I'm on behalf of the state. My lord, in this case-
for the appellate, my lord, I'm led by Mr. Shivashish Ghosh.
My lord, in this
Appearing
case,
online.
additional advocate general will appear, my lord. He is not well. My lord, the matter may be fixed on Thursday, my lord. He will do that.
He's not well, he said.
Yes, my lord, he will appear on Thursday, my lord. He come to court on Thursday.
And on health ground of a learned colleague. They kindly takes it upon Thursday, my lord.
Thursday.
Great.
I'm grateful.
My lord, I'm appearing for the petitioner. May I, my lord? May I, my lord? May it pleases your lordship, my lord. My lord, this is an appeal in bail in connection with appeal. So the conviction happens to be under section 376 and 354 and 302 of Indian Penal Code, my lord. My lord, the basis of conviction was a suspicion. What is, my lord?
Yes, yes. Is a circumstantial evidence or a
My
direct
lord, my lord,
evidence? Yes.
absolutely circumstantial evidence and one last seen theory, which was itself very faulted of PW 11, my lord.
So for that, the appeal has been admitted.
Yes, my lord.
So
May I
whether you were enjoying a bail
no, my lord.
during the
No.
entire trial,
No.
were not. And what is a life imprisonment?
My lord. My lord.
When the appeal has been admitted, I
My lord,
believe.
it's way back in September.
What is the stage of the appeal?
Yes, my lord.
What is the stage of the appeal?
Paper book is not yet been published.
Why lower court record has come?
My lord. Huh? Yeah, it is for 3 years.
The lower court record has come. Yes. Which court?
My lord, district court, Darjeeling, my lord. May I, my lord?
Lower court record is here. No. Session judge, huh? Correct.
My lord, now the.
So let the paper book be prepared within,
My lord, I am for last 2 years, my lord, I am incarcerated. And the conviction is very.
and you were not privileged with the bail
No, my
during the
lord.
trial.
And
So at least the trial has been concluded within 2 years.
my lord, 2020, no, 1 year. Offense
1
was
year.
committed in
So-
2022.
So we are directing the paper book to be filed immediately and let us see.
Man, my lord, then kindly fix a date for the appeal hearing.
So we are directing. First thing is the lower court record has come.
My lord.
Now the department has to prepare a paper book. We are
Right.
directing this preparation of paper book within a short span of time. Don't
Right.
worry. And then liberty is granted so that you can mention the matter and the appeal can be immediately disposed of.
My.
This is an application at the behest of the appellant for suspension of the sentence pending the instant appeal. The appeal is admitted on 3rd October 2023. No, not 3rd. 3rd is the correction order. Is admitted on 27th September 2023. With the direction upon the departments to prepare the paper book within 4 weeks from the date of the receipt of the lower court record. दिए दाओ तो एक बार रिकॉर्ड तो दाओ. देखिए वही कागज तो दाओ. Pursuant to the said order, the London District and Section Judge Darjeeling sent the record, sent the record with a memo dated 11/12/2023, duly received by this court. Astonishingly, after the arrival of the lower court record, there is no noting in the file that the said record has been received by the department. As a corollary effect, the time for preparation of the paper book is postponed and or kept in abeyance. It is not acceptable that the department, after receiving the lower court record, shall not put a note on the file, the date on which the such record has reached to this court, and after due verification, the same is found complete in all respects. The department is directed to immediately take steps in this regard. Stop. The department is further directed to prepare the paper book within 3 weeks from date, and shall ensure the service of the copy of the paper book upon the appearing counsels. Stop. So far as the suspension, the suspension of the sentence is concerned, we find that the session trial was conducted while the appellant was in jail, and which obviously lead to a presupposition that the applications for bail filed by the appellant during the currency of a trial was not entertained. It's a case, the trial court has, the session judge has found the petitioner, the appellant guilty of committing an offense under section 302 of the Indian Penal Code. And bearing in mind the seriousness of such offenses, we do not think that it's a fit case where we should allow the suspension of sentence pending the instant appeal. Full stop. In view, the application is the dismiss. However, liberty is granted to the parties here to mention the matter for early disposal immediately after the service of the copy of the paper book upon them.
Okay, along with 300 to 354.
In both the sections,
My lord.
Grateful.
he was never counted. Automatically right of appeal he had to honor that he was enjoying a break during the at which he can say we can suspend, but it is not a case. Yes.
Lordship is appeal against the identical lordship preferred by the de facto company.
So it's a formal order of admission.
Lordship, there was delay. 3 days
Oh.
delay to file the.
Have you filed a application for,
No lordship.
what are you doing? You're not serious about it. You know that there is a delay of 3 days. Can't you file an application for condonation?
We have tried to contact the applicant lordship.
Sir, the appellant is definitely a de facto complainant. You tried to contact and you could not contact. Then we are dismissing this appeal. Will what? It appears that the instant appeal has been filed beyond the statutory period of limitation provided therefore, without accompanying an application for condonation of delay. Stop. In the event the application for condonation of delay is not filed within 2 weeks from date, the appeal shall stand dismissed.
Number 6.
Appearing for the appellant. This is a jail appeal, Lordship.
Yes, somebody has to, oh, he is appointed,
Yes.
Mr. Aniruddha Biswas.
Yes.
Where is he?
I'm not able.
Oh, you are appointed as amicus curiae.
Yes.
Who is for the state?
Before admission statement.
Now the difficulty is, I tell you, please correct me because my brother, we have a vast experience in this regard, having conducted a lot of session trials. I was not privileged. So now if the appeal is filed in this fashion, what is the proper course? To appoint a lawyer to a legal services authority to represent, or their amicus curiae is sufficient enough to complete it? No, I'm just asking you, what is the procedure?
Usual procedure is to appoint a lawyer from the SLS.
That is what I was of the view. That's why I was appointing yesterday also.
Yes.
But I find from the order, there's only the amicus curiae is appointed. So I was really wondering that, is it a proper course? Amicus curiae is a friend of the court, will assist the court.
On a point of law.
Absolutely. Whether on a fact, whether on all these aspects, whether the amicus curiae can do it.
No,
You're not supposed to take a partition view.
no. I must stand in between financial.
Absolutely.
Let there be
Let him remain as a amicus, but we can appoint somebody else. So you remain, no difficulty, but we are appointing somebody else as for the. Come, give me the panel. Where is the Satyaki Basu? Oh, no, no. Then why his names are given in the panel of the? I do not know, why then, why? Because I find it's a 2009, his enrollment is 2009, so pretty senior. Appoint Satyaki Basu. Eight. You have given yesterday's order. Mix up. Yes, we are appointing Satyaki. Take back. No, he's registered as a criminal. That's why I was Satyaki Basu, civil and criminal matters. There is a. I am looking at it. That's why I asked. Otherwise, I would not have. I am conscious. Anyhow, then give me another. What is this? Another name is Arnab Saha. Who? The regular practitioner. Arnab Saha. Oh, these are the. Let's call the next. They're going to say that's why I am asking. Where is Mr. Parthaputin Sarkar? He is a regular practitioner. But I do not know, but yesterday also this matter was taken up. He did not appear. Parthaputin Sarkar, he is same, appointed as a amicus curiae. I am appealing for the state police. He's a very old appeal. True, that's why we wanted expedited. Still appeal and it was, conviction was awarded in 2013. So, all along this man is in jail. What about Narendranath Das? No, we have not been served with any documents. No. His name, Narendranath. He is a senior advocate, senior lawyer. Does he appear? Yes. Yeah. Because I find he's of 1983. Yes. Must be pretty old, an experienced person. Yes. Yes? Yes. And very sincere. Senior. Narendranath Das. Appoint. Number one. Next.
Milord, I'm for the petitioner, Milord.
May I? If in the cases where amicus curiae were appointed, will they remain or they will remain? I have not substituted them because their appearance is required. Lodge. Don't worry, amicus curiae is pro bono. Yes. Yes, next.
Milord, I'm for the appellant, Milord, petitioner, Milord.
363, 20 years
Yes, Milord.
already.
20 years old boy, my lord, and I've got
Years old boy, 20 years rigorous imprisonment.
my lord,
So
my lord. I've got I'm 16 days late
I
to
do
file
not know,
the
to
appeal,
run
my lord.
concurrently, okay,
My lord,
and 20 years is the outer limit.
my lord,
You are also prosecuted under section 4,
my lord,
POCSO.
my lord. I've got a relationship with the girl, my lord, and
What
the
was the age of the girl?
girl was 15 plus, my lord.
15 plus.
My lord.
How could you?
At the time of
How
this
could you-
incident, my lord, that boy was at around 18 only. 18 years only, my lord.
18 years, must be above 18 years because he's tried, not under the juvenile.
My lord. Just
He's tried
18,
as a
18
brother.
plus, my lord. He was not even 19, my lord.
Whether you were granted bail.
Yeah, there was a bail granted during the trial, my lord.
After how many, days of incarceration?
That I'll have to check, my lord. But during the enlargement on bail, my lord, that petitioner didn't misuse the liberty granted by the.
That is what
Milord,
I'm
Milord.
asking. After how many days of incarceration you were granted bail?
Uh,
You have the copy of the bail order?
yes.
Yes.
19 From the 16th, 10, 2021, you are on,
Yes.
you have been arrested.
Yes.
Got the file?
Not mentioned. There was.
না এটা 17 বছর তোমাকে প্রোডাকশন দিল এখানে মেনশন থাকবে না এবার তোমার কাছে নোট থাকবে 17 বছর
How would she?
documents which shows that he is the inhabitant of NGP police station on yesterday. They have said at first that residing at Siliguri. Subsequently, they have taken a plea that within the NGP police station. They have said. Panchayat authority is not a, it a bill, that is not a.
They have a power under the contract that. Then what can I? Aadhaar.
Bank account, at least bank account.
Residential. No, my lord. I am decided in a tenant house, in the under the NGP.
My lord, agreement part or the residential proof, I need, my lord, we need.
No,
Even my lord, a bank account disclosing his address.
my lord, in the local area, if you come there in Jalpaiguri, many person, my lord, kind of did not make any rent agreement. They just decide, no.
Money receipt you get.
2 years. 2 years.
Yes, my lord.
Well, it is a, no, well, it is not under the Siliguri, it is a Gram Panchayat under. But it is under the NGP. Not there, then there is a one,
Yes, my lord, receipt is there.
And in addition, my lord, subject to your lordship's correction.
well, then my lord, kindly direct the officer of the NGP whether I am decided there or not, my lord. I have come with the letter. If you want, we can deliver a judgment on this letter. Well, let them kindly give it a one more to take instruction.
But at least one bank account should be there, which mentioning his current address. That will, that even my lord, in the, nowadays, the daily laborers are much more conscious about the bank account because their wages will be credited there. So for my knowledge,
My lord, in the bank account, there is my residential address. What is my permanent address here?
what you mean your
What is
permanent
my
address?
present address?
You are residing at
Kindly
NGP.
appreciate the
They are
certificate of the Pradhan matter. Well, give me 1 day of accommodation. I will take necessary.
on last, they have said, I am residing in Siliguri. For your lordship was pleased to raise the point, they took a new plea.
My lord,
Well, I am not in position to say that. I am not in position to say that.
my lord, Mr. My lord, may I? My lord, last day Mr. Go is appearing. My lord, his son is 2 years old. My lord, he is ill, so that why he is go.
Maybe it's not tomorrow or day after tomorrow. Tomorrow.
Civil matters, sir.
My lord,
Civil matter.
the
Proceeding.
That I am for the petitioner, my lord.
My lord, I am for the petitioner. My lord, in this matter, service to the private responder has yet to be effected, my lord. My lord, kindly make it Thursday. State also. my lord. Grateful. Yes.
Direction change. Lord. Yes, Lord. Yes, yes, Lord.
Yes, my lord.
Lordship, service is completed, or Lordship is 3 of 2022. Yes, Lordship. No, Your Lordship, today I will send to the officer to the correction of Your Lordship for service.
Yes, my lord.
Lordship, this is the limitation point of limitation, Your Lordship.
No, Karnataka.
Karnataka.
Lordship, it is a single bench judgment, but my lord, if your lordship kind enough to go through the judgment, there are several Supreme Court citations quoted in that. My lord, that for this reason I was in a trepidation to place any judgment before your lordship. My lord always differentiates. My lord, we have another from Bombay. My lord, we have. My lord. Lordship. Lordship. My lord, in all fairness, he should be served an opportunity of filing an opposition.
Lordship, Jalpaiguri. Lordship, today.
Lordship, we have already sent the communication today itself. Lordship. My lord, same, my lord. The order has been served, but no opposition has come.
Condemnation of delay petition.
Same, my lord.
No, no.
No, my lord.
No. Lordship, you have already filed with the PAN application. There is a demand for 1429 days delay, Your Lordship. Lordship, you have already filed and service is already done. ওই সময় মূল ফাইল করার সময় কনভেনশন পেটিশন ফাইল হয়
No, my lord. Personal.
এখানে ক্লাব দিতে পরে নাই ভিডিওতে
Service.
Actually, my lord, service was affected by CBI itself. Only the forwarding letter was done by Mr. Singhania.
Nineteen 75. Para 4 constant.
My lord, may kindly take up paragraph 4 of the condonation application. My lord, we have enumerated how the file traveled. My lord, on 23/10/2018, the SP gave his comments. Then, my lord, there is a gap. I admit, my lord, that it is not clear that when the file was forwarded to ACB. My lord, I need to find out when the file was received by the ACB, HOB, ACB Calcutta. Yep. The ACB ফাইলটা কখন পেল? কোথায় পেয়েছে? উনি বলছেন যে এই 23/10/2018 থেকে 4/3/2019 এই গ্যাপটা কিসের? ACB কাছে কবে গেল? কোথায় লেখা আছে? বলুই না ওটা, 4 মাস ধরে ফাইল করে ACB। এই তো 3 দিনের মধ্যে 4 দিনে দিবি 15 ডিপার্টমেন্ট 7 দিন।
4 দিনে কমেন্টস করলে এসিবি সে ফাইলটা ফরওয়ার্ড করে দেবে 7 দিনে। 7 দিনে ইমেলে মার্ক থেকে 4/3/2019 এসিবি কলকাতায় ফাইলটা পাওয়া।
নেক্সট এই সার্কিটে করাটাই প্রতি। ये ग्राउंड किया पे
वो भी है सर उनका
my lord, we do not know, my lord. My lord, it was done in Calcutta, my lord. But we did not, we were not a part of that time. We received it much later. Yes, my lord. Which prompted that learned additional Solicitor General to write a letter. My lord, then I have to dig it out. Because my lord, if my lord takes paragraph 16. No. Was reassigned on 19/7/2009 by the learned advocate entrusted with the matter had returned. Whereas there was an appointment and a reappointment.
without any such restriction. And therefore, the court must take into the possible extent to occur. And whether the civil constitution sufficient cause in order to exercise the discussion is dealing with the cases regarding the contribution of the application vividly reflects the movement of the file from one department to another for the purpose of waiting and the approval to the decision of the public prosecutor and we are even there has been a considerable delay at the considerable delay in the hands of the council representing the PBR who was not vigilant enough to take a prompt step for which the learned additional solicitor general has to seek an explanation from later. How can you the letter? The council for no responsibility but recuse himself to appear in the matter or take steps. Yet there is no responsibility fixed, therefore. What we are going on, not find that there was any carelessness or negligence attributable to the other and the delay for document for the reasons so stated, which appears to be beyond their control. We therefore allow the application for what was the judgment of the Karnataka High Court and what was the judgment?
It's the same, your language and all that stuff.
Lordship, the
Item number 11, your lordship.
Lordship was,
Here, Sabta copy.
Lordship,
11, item number 11.
special collection order.
Appears to be too energetic.
Superintendent Jalpaiguri Central Collection Order. Lordship, the service of 11 has come. But we need to file an affidavit. No, but I'm just intimating the honorable court that the service has been affected. 2 days. ये तक Lordship, in item number 12, can it be taken on Thursday? Eleven, Lordship.
Yes, I'm praying for a short pass, Your Lordship. Lordship. Yes. I am for the statement. Lordship, the senior counsel will move, Lordship. Devoshidhar is moving in court number 2, Lordship. He's moving in court number 2, Lordship. Watch out.
I mean, brother.
Lordship. In my application for relaxation of the conditions, Lordship, or anticipatory bill.
Present status of the trial form. Seventeen is fixed for supply of cotton. No, last objection 9 has been appeared before the. They did not appear. No, Milord, the copy has not been supplied. After supplying the copy, thereafter the charge will be paid.
Lordship, I am agreeable that the petitioner shall make herself available before the jurisdictional police station once in every month. Also, the charge sheet has been submitted investigation as well. I only this much. I am ready to face the trial, Lordship, every day. Lordship, I am a resident. I am a resident of Kuchibihar. There is no, Lordship.
Yes, my lord. Ex-chairman of municipality.
These are all allegations.
Near about 2 crores, my lord, the amount involved. Yes, my lord.
I'm grateful to your lordships.
This is my application for anticipatory bail. The allegations, my lords, are under section 406 and 420 IPC. 406 and 420 IPC. If I can have my lordship for. My lords, if I can have my lordship for a moment on page 10, which happens to be the FIR. Lords, page 10 is the FIR. No, my lords. Actually, if my lords happen to see at the FIR, my lords, the incident is alleged to have happened between 19 November 2019 to 26 January to 2020, and the FIR is launched in 2023. I deny, my lords, that I have placed any order. My lords, my lords, Lord, section 41A notice was served upon me, my lords, page 16. I have complied with it, my lords. I have complied with 41A. I will face the trial.
41 complaint.
Lords, 19/11/29. Lords, the FIR says 19/11/2019. I'm so sorry, lords. I'm deeply pleased.
Yes. This is my application, my lord. This is application for anticipatory bail, my lord. Charges under section 498A, 304B of the Indian Penal Code, and my lord, section 3 and 4 dowry prohibition. Yes. Has been in custody. No, my lord. Husband is in custody, my lord. The father-in-law and mother-in-law. My lord, 41 and 39. And my lord, there is a love affair between them. They plead away, they subsequently married and residing in a separate mess, my lord. And the boy and girl, my lord, 20 years only. one for 41 father-in-law and 39 mother-in-law. As per my lord, Aadhaar card. Yes, my lord, he is in custody till now. Yes.
Item 17, I'm paying for not today, my lord. Not today. Not today. Major lady, my lord.
No, those are the minor sons.
They went together with the lady.
Actually, the fact of the case is that, my lord, yes, okay. 80,000. My lord. My lord, this son, he had 11 times he was operated. And after that, this person, this petitioner approached them and said he has a good connection in the South India. So he'll be taking them there for the treatment. He took 80,000. He took the 164, very serious allegations of there. Even in the affair also. And after taking that, she was kept in a separate room, whereas 164 is page number 23. Yes, Shagina. Sorry.
Well, kindly hear me for a moment. Well, lady went with her son. There is no statement of her son recorded. It was taken up for hearing earlier coordinate bench. Well, there is a verbal direction. Kindly record the statement of the minor's son. Well, there is no statement. Kindly see any document was seized regarding Bangalore. Offense was committed allegedly at Bangalore, my lord. Not at only statement where recorded neighbor of that locality, my lord. Well, her statement, my lord, kindly consider there is a monetary transaction.
Sufficient.
There must be a corroboration. There is no children's statement. There is no other statement. But her statement cannot be a sacrosanct, my lord. There is no child
Right
statement.
statement, my lord. Just check. on the
They
last-
will be the best witness, my lord. Whether they no my lord, they went my lord, they went my lord, they went with her or not anything, anything, my lord, anything. Well, only her statement, my lord. There is no other corroborative evidence, my lord. Any document was seized. How many days stay? Or nothing, my lord. Well, it's in the affair, my lord.
Trusted this petitioner, he went for the sake of the child. He has been with her to Bangalore, stayed there in a separate room. At night, she was raped. Not only that, not only the petitioner, then the petitioner called their friends also, relatives who had enjoyed sex with her. No, my lord, statement only. Medical is there. She is a parasmemel, so already medical is like. Yeah, she is parasmemel. But the allegations are very. The affair is also very. Custodial interrogation is required. ma'am. Grateful.
No, item 18, I want to not press this application. No, no, no. You will grant regular bail, otherwise, no, no, no. If your lordship observes and no, not might be, but can gain regular bail, my lord. Otherwise, some observation it will be difficult to get regular bail before the court below also.
My lord, I am for the petitioner. My lord, in this case, Mr. Sudeep Go is appearing on behalf of the petitioner. My lord, his child is ill. That's why he is going for a Shiliguri. My lord, my lord, kindly make it not today. Get.
Very serious allegation. The DSP he is coming, is investigating the case. Every day he is coming there. So, this has been interesting because it's a huge scam of 1 crore 9 lakhs. Departmental, my lord. The civic volunteers accounts were opened and entire money was shot. Not, yes, I from there. And the investigation has been done.
Yes. Sure. Good.
My lord.
Yes, my lord, this is my application. My lord. Charges under section 302, my lord. Kindly, yes, my lord. Kindly see paragraph 6, my lord, for a moment. 6-7 minutes. Son-in-law and petition number 2 is the son of the petitioner number 1.
KMM 4851, page 14.
And my lord. Kindly see the 164 statement.
100 PM. Thank you. ¿Cómo estás ahí? Cases that been started on the. No, my lord. Yes, my lord, daughter, page number. Daughter, yes, my lord, page 16. 164.
Only, my lord, my lord, may I submit one thing? But only, my lord, kindly consider petition number 2, my lord. My lord, Budot Motors is the petitioner number 1, my lord. But son is the 2, my lord. He is 20 years old, my lord.
That's it, submitted. 21, my lord, 21. My lord, Ms. Suman Shianov is appearing for the petition. My lord, she has suffered a bereavement in her family, my lord. So lordship can kindly keeps it in the next circuit, man. Suman Shianovish, Mrs. Suman Shianovish. Shianovish. No. My lord, she is not the advocate on the court, my lord. I'm sorry, my lord, wrong instruction. Yes, sir, I'm sorry. Wait, 22, I appear for the petition. I'm for the state. My lord, the petitioner is renewing his prayer for anticipatory bail before your lordship, my lord. The first rejection, my lord, is at page 8. Yes, yes. First one was rejected. No. No, CRR, my lord, was filed against the order of proclamation, my lord. And that order of proclamation was set aside by the honorable single bench. The rejection is at, my lord, page 8. My lord, initially the Lordship. Will be a sole child. My lord, the FIR was initially under 376, 511, 302. Charge sheet, my lord, is under 376, 511, and 306, my lord. Now, 376 possibly cannot lie because the admitted fact, my lord, that the petitioner and the deceased were in a relationship. Yes, the husband admits, my lord. The husband of the deceased. What? That
They were in a relationship, my lord. The husband is the FIR maker, lord. Yes. And the FIR, my lord, he says that they were in a relationship. Not a relationship, I think. Yes. Yes, my lord. Yes, very sure. I couldn't read properly. So difficult for me as well. But in the body of the affair, this type of allegations are there. She used to forcefully. No, no, not forcefully. They were in a relationship, my lord. Yes. Consensual. Not a case of consensual relationship. No. Consensual relationship. No. Then there was an kind of a salishi. Even after that, there was kind of a salishi, my lord, that I will not visit the deceased again. But that is similar, it has been written. After that also I visited, my lord, and when the husband came, they found, the husband finds me and the deceased there, and I run away. No, no, that is not the case in the investigation, that is developed in the investigation. Completely. I am not aware of. Cash sheet has been filed, my lord. চাষিদের ডেটটা আমি যাই না, চাষির আছে তো পেশ হবে। হ্যাঁ আছে, 31/8/22। After submission of charge sheet, he kept on absconding and this bail was rejected. He continued to abscond. Thereafter, WPA was issued. Thereafter, he got the WPA set aside and again filed an application for anticipatory. Conduct is very careful.
Worships. नाम दे दो। After the statement. Second,
My lord, the conducting advocate is not here because of his child illness. Mr. Sudip, his child illness is not able to come.
24, my lord, Mrs. Shianovic is appearing as a counsel in this matter, my lord. Ms. Shubhan Shianovic is appearing as a counsel in this matter, my lord. No, my learned friend is there. Uh, No, my lord, will it be lordship's pleasure to take it up tomorrow? Then I'll get myself ready in this matter, my lord. So lordship takes it up only next day. I'll get myself ready on this matter.
The allegation is that, my lord, one, that he has not been recovered. No, no. Because nobody has been arrested, so none has been arrested in this. And all are absconding. The allegation is that this FIR named accused number 2, that is Renu. My lord, I'll just call the IO, my lord, in that case. Thursday, my lord.
My lord. My lord, under compelling circumstances, my lord, I'm let me mention, my lord, item 246. But I have been informed by the counsel in the learned trial court that the learned trial court had fixed the matter at 4:30 PM today, waiting for the orders of the honorable court. So, my lord, my lord.
Grateful.
Yes.
Lordship, I beg to appear on behalf of the petition.
Why you begged, madam?
Lordship, I appear on behalf of the petition. Lordship. The allegation under section 18C of Narcotic Drugs and Psychotropic Substances Act. Lordship, allegation is of illegal plantation of poppy plant. Lordship, co-accused has already enlarged on bail, Lordship. Page number 14, interim bail. Later on, it has been confirmed, Lordship, by the learned court below. Lordship, charge sheet has been submitted, Lordship, under section 18C of NDPS Act. Lordship, on 25/9/2023, Lordship, page number 11. Lordship, this present petitioner is also a senior citizen, Lordship. Aged about 59 years, Lordship. They are illiterate.
Senior citizen, 59 years. From where?
Lordship, 1 year.
So,
Lordship, they are the illiterate person. They have given their land in lease, Lordship. They don't have any
to whom?
other person, Bhakchashi, Lordship. Lordship,
Was there any recording of Bargadar?
Lordship,
When you talk about the Bhakchas, was there any recording of Bargadar in the record of rights?
Lordship, in the village, Lordship. No.
What are you talking? The West Bengal Land Reforms Act extends to the village.
Lordship.
So, when you talk about Bhakchas, then there must be a recording of Bargadar. Are they a Bargadar?
Lordship, then I have to take instruction.
What instruction?
As per the Khutian issued by the BLN, the Khutian number 95 and 96 and plot number 62 and 63. They are the recorded ones.
Correct.
As per the government record. And
Correct.
the poppy plant has been
Yes.
found at the same bottom.
Who was found?
1,000.
Who was found cultivating?
Yes, my lord.
It is a prime.
The
Is
present
a,
petitioner and his brother.
no. What is his brother's name?
Brother's name is Jitendra Gorango.
If the Gorango has been granted bail, if they are the joint owners, then why he should not stand on the same footing?
They are not the joint.
You said that they.
The separate Khutian. Khutian number 95 belongs to
Gorango.
Gorango and 96.
Correct. So even if the Gorango has been granted bail by this court, then same footing. The parity is one of the hallmark of, and that was also an anticipatory bail. So why not? We can see the parity. So
But huge quantity of poppy plant has been.
here also 1,000 opium poppy plants. In this case also 1,000. Have you seen that order of Gorango?
Page number 4.
Same, second paragraph, 1,000 poppy plants.
Yes.
So if this stands on the same footing, then whether regular bail has been granted. So we are passing the similar order. They will go and ask for a regular bail before the court within 2 weeks.
Some condition.
What? The conditions is there. The condition is there that they have given an undertaking that they will cooperate with the investigation, and on further undertaking that he would surrender before the trial court within 2 weeks. So this is the same thing.
Yes.
No problem. Similar order. Page 14. Now, একটা শুধু paragraph. It appears that the co-accused who stands on the same pedestal that of the petitioner was given an immunity from arrest for a limited period of 2 weeks with the conditions that they would seek a regular bail from the concerned court. So, since the petitioner stands on the same footing that of the other co-accused, namely Gaurango Mondal, who has been extended the benefit of pre-arrest. Video order dated 9/6/2023 within bracket CRM E 296 of 2023. We do not find any justification in not extending the similar benefit to the petitioner. No, 2 weeks to arrest করবে না. May not be arrested for a period of 2 weeks from there. করতে পারেন সেই জন্য করতে পারেন না এই লাইনটা দিলেই একটা বেরো দিতে হবে দিতে হবে এবার আমি দিলাম কালকে রেখে and what the country for the anticipatory বলে তো গ্রেভে কি বলবো যে এখানে দেখা যাচ্ছে যে investigation is going on, let me go and surrender. এই জন্য রেগুলার পেরিতে যদি জানতে গেলে ওখানে আগে তো বলেছি considering the material from the court যা আছে ওখানে কনসিডার করতে নাও the question is future can consider the
Second तरफ earlier order
করে দিলে কি হয় আমরা তো পুরো
get put.
My lord, praying for short passover, my lord. Conducting advocates, code number 2. Sandeep Gorai.
Third application for third application for anticipatory bill.
Yes.
I am for the petitioner, my lord. My lord, this is a mercy petition because, my lord, it is a fourth application under section 430. It was previously thrice rejected by your lord.
So then mercy requires. If thrice it has been rejected, then where is the mercy?
My lord, praying for mercy. My lord, petitioner is a 50 years old lady, my lord. All the other accused person are on bail. This is a case under section 341, 323, 325, 326, 307, 354, 506, 34. Later, section 302 has been added, my lord.
Yes.
Out of a civil dispute, the present incident happened, allegation of assault by the sharp cutting weapon, my lord. All the other accused person, there is a 5 accused person, 3 accused person are on bail, 1 is in custody, my lord.
On such a auspicious day, can it happen? Can it happen? The object and the purpose of, I think, celebrating that particular day is totally frustrated from this.
This is the allegation.
What allegation? The day is celebrated because the pupils will forget and forgive whatever they have done. And there should be a complete harmony in them. They just plead, the forgiveness and embraces each other. And on that day, this incident happened. Then
Russell is on bail.
why don't you face the interrogation from them? Why?
Charge sheet is already been
So
submitted.
whatever, that was also submitted earlier.
During further investigation, PC can be taken, Lord. No, but charge sheet can already been submitted. Lord.
But there are many things which will come. There was a complete commotion, as it appears from the earlier order.
Or I will cooperate an investigation agency, man. If there is any need for this. That gate will open.
And you have not justified your name also. You should show compassion. You have not.
No, that's why I'm praying for mercy.
No, listen.
Kindly, my lord, there's a charge sheet has already been submitted.
That was also submitted earlier. So,
No, all the other accused person are on bail.
no,
The principal accused is in custody.
no, that says,
All the other accused person are on bail.
no.
Two order has been annexed. One is in my hand, my lord. Kindly see.
No, yeah, we have got that order. There are certain
Bail
people,
has been
the
granted by the landlord.
Raushan Ali has been granted bail. We have seen that,
Not only same booty.
but
I'm on the better footing, my lord. Because the principal accused already is in custody, my lord. There is no need of my custodial trial, my lord.
when the charge sheet was filed,
My lord, charge sheet is filed on 2020,
21st January
2020.
21st January 2020.
so,
My lord, any stringent condition, my lord. Any stringent condition.
and
50-year old lady, my lord. What is?
your last application was dismissed on 12th of July,
Yes.
much after the charge sheet.
Thereafter, one accused person granted bail, my lord.
So whatever.
Kindly see.
What is the name? We have got all the copies. By the trial court.
By the trial.
Oh, sorry, we don't. What is his name?
Russell Ali Ahmed, my lord. There is Roshan Ali Ahmed is already granted bail by the TVL.
No, no, Roshan Ali I have found here.
Yes, ma'am. Personally, and this petitioner are not on same footing. No, the better. Kindly see.
Whereas
Kindly see
the,
my involvement.
where is the Rashid Ali? Well, Rashid Ali is a different.
Yes, ma'am.
Roshan Ali and Rasil Ali is different.
Yes, ma'am. Here is the Russell Ali. Mail order of the Russell Ali, my lord.
Granted,
Granted, my lord.
despite the rejection of the application by this court, 439.
No, no, 439 has been granted by the land.
By the-
court. Here is the order.
Very interesting.
Yeah, I'm going to copy them. No.
No, no, ঠিক আছে, ছেড়ে দাও, দেখে নিয়েছি। I do not know. Prosecution, they will never. They don't care. They don't care.
17 station reject. এখানে bill দিয়েছে।
They don't care.
Yes, after the previous rejection.
Reject হয়েছে তাই, দেখো। Reject হয়েছে। And that was rejected on 12/7 when the charge sheet was already filed on 21st January. No. Please file project 3. So, I'm going to use the Russian editor. It was there on 12/7 it was there. So, rejected. What is it? Yes. No, it was rejected. No? This is the 4th application
Yes, ma'am.
seeking anticipatory bail in connection with the aforementioned case. Earlier 3 applications were dismissed, were rejected by the court. And last of such rejection can be seen to have been made on 12/7/2023. Pass in CRM A 514 of 2023. The counsel for the appellant claims parity with Roshan Ali
Roshan Ali and Russell Ali.
and Russell Ali, who have been granted bail by this court as well as the trial court, respectively. It is no doubt true that the court, if found that the accused stands on a same footing that of the other co-accused, can grant bail on the ground of parity. We notice that we notice that although the charge sheet has been, the charge sheet had already been filed on 21/1/2023, yet the application for anticipatory bail filed by the petitioner was rejected on 12/7/2023, and therefore filing of the charge sheet cannot be construed as a change circumstances for the instant purpose. Furthermore, the application for anticipatory bail, application for regular bail filed by the Roshan Ali Ahmed was allowed by this court on 2/5/2023 in CRM within bracket DB 187 of 2023. So even after the said order, the last application filed by the petitioner was dismissed, obviously taking into account that the petitioner does not stand on a same footing that of the said Roshan Ali Ahmed. So far as the Roshan Ali Ahmed is concerned, his application for bail was rejected by this court on 4/10/2023, passed in CRM within bracket DB 613 of 2023. We are surprised that despite the rejection of an application for bail by this court, his bail application filed before the trial court had been allowed. The court cannot go simpliciter by the fact that the co-accused have been granted bail unless the court assimilates the facts discerned in course of an investigation and the conduct attributable to the commission of an offense, it stands on a same parity. Since the earlier applications were rejected by this court, finding that the petitioner cannot avail the benefit of the doctrine of parity, we do not think that there is any change circumstances for extending the benefit of pre-arrest to the petitioner. The prayer for anticipatory bail is rejected. Given a regular bail order, sir, or reasoned order.
For the petitioner lordship. This matter pertaining to an allegation under section 406 and 420 of Indian Penal Code by an order dated 1st of February 2024. This matter was adjourned with an interim order, lordship, with the direction upon the petitioner to place
Produce the vehicle before the IO.
Exactly, lordship.
Produced.
No, lordship, that have what happened?
Just wait.
There was a specific direction, madam.
So who was supposed, the petitioner? Why you did not produce the vehicle?
Because the petitioner has gathered information that the present vehicle, the subject vehicle is currently lying at the Gosaigao police station in connection with a particular case which is registered as registered in the state of Assam. That vehicle was somehow associated with some offense and it was detained, and the vehicle is lying with the particular police station. That case reference has been gathered, but the relevant copy of the case has not yet been available. But if the copy has been applied for, it will be shortly be available. So on that score, lordship, I could produce all these things, lordship. I am ready to produce.
But you were supposed to produce all these documents to the IO.
Yes.
That this is what has happened. There was a direction which was given that on or before February 17, 2024.
Yes, I communicated all this incident after passing of this order to the IO. IO has also sought for the copy of the particular order of detention, lordship. I applied for, the copy is not yet available. It will be shortly available.
But as per the IO, he has not been informed about this.
So
no, lordship, my client has stated the copy.
There must be a receipt.
No,
that you have communicated by a letter that I am supposed to produce the vehicle is lying there in connection with this case, I am unable to produce, this is for your information. So they can have a corresponding, they might have a reciprocal one, they could have gathered that information from that police station.
That no formal communication in.
Then why you will not? Then why we will grant you or extend you a benefit? If you are a defaulter in committing a particular directions passed by this court, do you think that the blessing should still be extended to you? Why?
So what happened, lordship? I'm just.
But why you did not communicate in a letter when there is a direction?
The lower court advocate of the.
Yeah, sir. The order is passed by the High Court.
Yes.
You are appearing.
Yes.
Then what is your role? What is your role?
The concerned advocate has communicated.
What concerned advocate? Are you not a concerned advocate in this case?
True.
Then,
But I didn't approach with the investigation officer directly, Lordship.
no, why you will approach the investigating officer? Only thing is that the proper advice is to be given so that
I
at least
given.
have you taken any receipt?
No.
What? Then why? What is your role as an advocate on record?
এই সপ্তাহের মধ্যে পেয়ে যাবো, এই সপ্তাহের শুক্রবারের মধ্যে পেয়ে যাবো।
Absolutely casual and.
Can it be taken up on Friday, Lordship?
Have you not been able to arrest him? Why you did not?
Vehicle is lying in the different police station, Lordship. I mean, it is not in my position. And even if.
Sir, I appreciate. Are you not appreciating what is passing through our mind?
No, exactly, Lordship.
So there was a deadline which is given in an earlier order passed by the earlier coordinate bench. If you see that you cannot comply because of this impasse having been faced, is it not your duty to inform that this is what is the real picture?
I'm must be candid, Lordship. I am told that the concerned advocate has communicated with the investigation officer over phone, and investigation officer.
Over phone will not do. What is a
The usual practice, Lordship, what happened? That
usual practice?
The lower court advocate has told me that, Lordship, this is the.
This is, I don't think so. If there is a mandate given in the order, then at least what is the responsibility of a lawyer? You should.
True, absolutely. I have no reservations.
If now the denial has come, who will justify that who is correct?
Absolutely.
Whether he or your counterpart in the trial court?
Absolutely.
What is a question of belief and disbelief?
Absolutely.
Then
It may be taken up on Friday, Lordship. I believe that copy of the relevant document I will.
give a letter to them immediately, today itself, and just see that what has happened in the meantime. We are keeping this on Friday. You have a reciprocal, the contract with them. You can contact that particular police station just to see whether. Yes.
My lord, praying for not today, my lord, the same advocate.
Yes, next.
29. Same, my lord.
Yes.
30.
My lord, kindly a short password may be given, my lord, for item 30.
Who is appearing?
Mr. Jadip Kant.
Where is Miss Rupa Basu?
She is the advocate on record, my lord.
So she must appear. Who is for the state?
Actually, no matter that relates to NDPS, you'll also kindly take the page number 10, paragraph number 5. Only being the owner of that vehicle.
27 packets of cannabis.
That is recovered from those persons who are in custody. Now, if your lordship kindly takes a pen to peruse, the page number 10, paragraph number 5, the only allegation against me is a charge sheet. Kindly see. Commencing during the investigation, my lord. NDPS, CRM A হচ্ছে 123, CRM A 123।
Filed by Shuri too.
No, Rupa was.
Well, one more. This is one of the political, I mean, actually told sales. আমি ছেচল্লিশে 46 আমি এদের নাই There has been a mistake. There are two filings in the name of Gopal Barwan. One is item number 30 and the other is item number 46.
That is not the same person.
They are not the identical, same identical. person.
Identical, not identical person.
Who is appearing in 40?
46 I am there, but.
No, this 30.
30, my name is written, but I have not received the brief and it has been, there has been a mistake in that.
No, same case not. It relates to Moinaguri police station. In that case, Gopal Burman and another, and I am only Gopal Burman. The name are identical, but the people are not. They're the only accused who is seeking pre-arrest bail before your lordship, because rest two are in custody. We can consider.
On Thursday, my lord.
No, we want a CD in this case.
My lord.
Ensure that the CD comes. We are keeping this matter on Thursday.
My lord.
Ensure that the CD comes. This call.
I'm for the petitioner. My lord, the petitioners before your lordship are the in-laws. In-laws.
Of
The de facto complaint as well as the
de facto complainant.
my lord.
In-laws of the de facto complainant. Okay.
No, my lord.
In-laws 3,
Four in-laws. Four persons are there, except husband, 2, 3
no,
and
3 I find. Shubhas,
My lord.
Jayanti and Nilkamal.
My lord, except husband.
Who is the husband?
Husband is the Shashi Bhushan Rai, who is not approaching for PRS well before lordship.
Correct. And who are you, Subhash,
Subhash is the father-in-law,
Jayanti
mother-in-law, my lord,
and Nilkamal?
elder brother-in-law of the husband.
Elder brother-in-law of the.
My lord, elder brother of the husband. Sorry, my lord. Now, my lord, kindly see the page number 9.
Is under
498 and
302.
307, my lord.
Oh.
And my lord, if your lordship kindly take the page number 10 at the left portion bottom line, kindly see. She attached a emergency ticket, Xerox copy of Jalpaiguri Medical College and Hospital dated 14th December 2023. I'm right, my lord?
Yes.
Now, my lord, kindly see the page number 9. From the bottom line, my lord, 6. From the bottom line, 6.
Yes.
My lord, may I permit to read out?
Yes.
এরপর গতকাল 24
Just
তারিখ
let us find out.
from the bottom line backwards 6.
Yes. 7th line. Any 7th line from the bottom.
7 lines for the bottom, my lord.
এরপর
গতকাল 24 তারিখ সকাল 10টা 30 মিনিট নাগাদ আমার দাদাকে সাথে নিয়ে শ্বশুর বাড়িতে যাই এবং দাদা বাইরে থাকে এবং ওদের বাড়িতে প্রবেশ করার পর আমরা কন্যার খোঁজ করলে আমার স্বামী শ্বশুর শাশুড়ি ও ভাসুর সকলে মিলে আমাকে চুলের মুঠি ধরে মাটিতে ফেলে কিল চল so and so. Now, my lord, so far the allegation is concerned, the alleged date of incident is 24th December 2023. And so far the emergency ticket she attached with the FIR that shows, as per her version, 14th December 2023. If I assume her story not admitting, on 24th, we have tried to kill her by attack her with a bottom. But so far the medical report is concerned that she annexed in her FIR that is reveals dated 14th 12. In the bottom line of the page number 10, left side, my lord. Now, my lord, so for my instruction is concerned, my lord, she left her matrimonial house 2 months prior. Subsequently, she realized maybe that I have to take a judicial steps against them. With a fabricated version, she lodged a complaint. So far, her version is concerned, my lord, she was attacked with a wooden bottom, but injury is, I think, doesn't support her version. Incident occurred on the 24th. She attached a slip of 14th. Even left her daughter with us.
May I get the CD?
Since December.
May, just wait. May I get the CD?
Now, the custody of the husband is not illegal, my lord.
The de facto complaint is restrained from.
She left her matrimonial house, leaving behind her daughter.
Five-year-old minor girl, the de facto complaint is restrained by the petitioner.
If we took a glimpse of the section 6 of the Hindu Guardianship and Minority Act, father is also a natural guardian, sir.
What?
Father, she has said the father, the girl with her father. It is no harm. She left her daughter with me.
No, you talk about the
Section 6, my lord.
of the
Hindu Guardianship and Minority Act. So from my little
two
understanding.
guardians and minors, no.
Guardian to persons. My lord, I may be excused, my lord. Section 11, 12, 6. Custody of child.
You have chosen a wrong person to say this. That's
I
why.
have just, due to my mistake, I have uttered the wrong act. Because I have not so audacity to
No.
mislead your lordship. I have learned from you. Really?
I don't mislead, I misinterpret.
That I have learned, and that has been modified by Mr.
Who's the medical?
There's no medical.
No medical.
He has not collected the medical. It's a case of 25th of December.
He has not collected means?
I just asked to the IO.
What he is doing then? Why he has not collected the medical? Where is the medical? She must have been.
There is a case under section 307.
So the medical is inevitable? I'm directing the SP to take immediate action against him. Why he has not done?
But
If one emergency ticket, the de facto annex to the FIR. Apart from that, can you see the FIR, the bottom line, page number 10?
Where is that? This is an FIR, this is a complaint, this is a attach, where is, this is her document, where is the attach? Name.
But By today evening, you
No, we are directing immediately, and this service record, the order should be there so that at least at the time of a promotion, everything is to be done. And we'll say that something is to be done in his service record. What is doing? Second, no, we do not want to hear it. This is a high court. And where is the annexure? Does not find place here.
in the FIR, there is an annexure.
Where is?
It is not in.
Then, if there is an annexure, where that document has gone? Where is your annexure? No, he has said that the ticket, photocopy of the emergency ticket of Jalpaiguri, the government medical hospital. Where is that ticket?
Actually, they have written it wrongly. This is the 14th.
No, I really wanted to know.
This is the dated, this is dated 14th of November. This is actually what they want to say, this is the thing. It's dated
No, this
14th.
is the discharge certificate.
Discharge, they have written it wrongly as a ticket. This will be the actual, because the date is same.
No. It is from here they got it. And this is what they have taken. It is there.
Hello?
Correct date. Is not a mistake.
No.
It is the correct date. It is the 14/12.
14th.
And what is there, sir? What is there? You are talking about an incident which happened on 24, and then you are annexing a copy of the another one at 14. You have said, please, you have said the alleged physical assault, same day discharge, and what is the medicine which is prescribed to you?
Only thing is that
What is the utility of this thrombophоб? Thrombophоб is a local anesthesia. Is nothing. Then, sir, if there is any
The defectology is restrained from looking into the daughter.
sir, then you have the different laws.
And they are threatening the defectology.
I am asking you, you have a different laws, sir. I do not want to assume the advisory jurisdiction. We are not, but this is a case of such nature where you will rope in the father-in-law, mother-in-law, and the elder brother. If you are detained from meeting with your child, you know what is the law.
Husband is absconding.
Whatever.
He has not absconded.
Sorry. And don't allow us to make any comment on this. After looking at it, very difficult.
The husband should be detained.
That we can't say anything. Which Thana? Which?
Managuri police station. Managuri police station.
And where she was examined?
Medical college and hospital.
Jalpaiguri.
go and collect by 3:30 and give it. It's nearby. Go and collect, otherwise we are going to record. Take him, send him the papers so that he will be able to say. Come at 3:30.
I'm for the state of loss. What? I'm for- State is ready with the.
I'm for the state minor.
In this case, the allegation made by the father of the father that the her minor child got married with the petitioner number 1 and petitioner number 2 is the father. Petitioner number 1 got is 20 years age. 20 years age.
Minor kid.
He married the minor daughter of the. Yes, Your Honor. Married. Father of the one. Father of the petitioner number 1. Not other party.
Give indigence and lordship 164 is clear, lordship in the envelope. Forcefully married. And she is aged about only 16 years. Wow. Under envelope.
Other
Yes, Lordship. This petition is a registered owner of a commercial vehicle, Lordship, and 290 grams and 10 packets of nitrazepam tablets were seized from two persons, one of driver from this vehicle's Lordship. From this, from their position, they are in this vehicle. Lordship. This petition is a registered owner, Lordship. From the FIR to Lordship charge sheet, there is nothing against this petitioner, Lordship, commercial vehicle. And Lordship, in the charge sheet there that this petitioner is abscond, this is totally false, as because this petitioner received the 67 notice from the police compound and several times attend the PS Lordship. He was not abscond, Lordship. And no allegation against this petitioner.
Not cooperate as per, at the time of filing charge sheet, his name is transparent and note. But charge sheet says different, showing absconding.
No, Lordship, W prior, Lordship, there is a prior Lordship, W. Yes, but
Lordship, he is the owner of the vehicle and yes, Lordship, is it? But till date, he did not pay for returning the vehicle, nothing. But he is. Lordship, but in the charge sheet implicated him as a accused in this case, your Lordships. Up to Lordships.
yes, Lordship, Bolero.
Bolero. From the RC, it is revealed that it's commercial.
Yes, Lordship. And Lordship, in the forwarding report, Lordship, they have specifically mentioned that if those from the narcotics are recovered, they stated that they procure the brown sugar and tablets from elsewhere for the purpose of selling the same. Lordship. Yes, Lordship. Yes, Lordship.
Others no, nothing, your Lordships. Except that he is the owner, he did not try to. Yes. is the CDO. 7-3. Lordships, in the RC, Lordships are charge sheet.
Lordship, kindly please, Lordship, please number 10, Lordship. Last question, Lordship, last para. As per instruction, Lordship, my client.
Lordships, here the RC, ownership is individual, you know. But it's not a commercial. Lordships, then I will take instruction from the IO. Now issue the RTO certificate. Actually, our lordship, the private vehicle WB 74 and commercial.
In Siliguri, under the Siliguri RTO.
74 private
4 is the private.
and 73 the commercial.
Somewhere it has to be written. Yellow. But somewhere it has to be there, Malad. It is in the RC book, registration certificate. Malad, can we just take a look?
Lordship, my objection kindly be noted as because of my instruction from the IO that he is involved as because he didn't pay the return back the even he tried to several times to arrest but could not succeed.
Yes, Lordship, Lordship, this petitioner received the notice under section 67 from the police compound, Lordship. Yes, Lordship, they received Lordship.
Complied not.
I would receive Lordship, there must be in the CD, Lordship. Put in signature and receive.
But no complied nothing. But I called the IO, but he is unable to today attend. You will record your picture and then we will make certain observations of your structure. So that IO where this structure you will make him understand. Okay. Actually, lordship, the provision, they have issued a notice and thereafter, after receiving that, they appeared before the court and registered in the CD, but there is no reflection in the CD, your lordship. No, such type of.
Lordship, he attended several times before the police station, lordship, before the IO lordship. The statement recorded by the IO lordship. By the IO lordship, I will interrogate him with some query, he answer them lordship.
If we always not ahead with positive, much better off now with the South Indian hates my. I.
My lord, I am for the petition. May it please your lordships. No, my lord, anticipatory bail. 438. Yes, my lord, that has been wrongly done. My lord, these two petitioners, my lord, their name transpires from the confessional statement of the co-accused persons, my lord, who were apprehended during the raid. And my lord, which is inadmissible in evidence, my lord. There is no other incriminating materials against these present petitioners before your lordship. My lord, my lord.
My lord, I'm not finding the names, my lord.
Yes, yes. See it.
Any kind of
We were supposed to read the, my lord. My lord, these accused petitioner was supposed to receive the clandestine, my lord, illegal cough syrup, my lord. But their names have not been transpired in the 161 statement, my lord. Only they have to, yes, my lord. They were supposed to receive, my lord. That is there in the FIR, my lord. My lord, during interrogation, names among, yes, ma'am.
No, my lord, two persons.
Two persons, my lord.
My
Yes,
lord.
My lord, three of the persons have given the exact statement, my lord.
last night,
Yes, my
what you
lord.
have done,
Interrogation, my lord. Investigation is going on. No, my lord.
why?
Investigation is going on, my lord.
Statement, okay, that's the last.
My lord, who I have shown, my lord, one more is there, so he knows. My lord, page number. Before that statement, my lord, before that. Yes, my lord, yes, my lord. Before that, my lord, one more, before that, my lord, one page earlier, my lord. So he knows. No, man.
Lord, police is looking around me, Lord. No, no, my lord, with respect to
kindly
this case.
look at this underlined portion, my lord.
Lord,
My lord, during interrogation, my lord, what is there? During interrogation, driver of the truck, but 161, it is not, during interrogation, driver of the truck, namely Mohammed Fahim, and handyman of the truck, namely Jishan, stated they produced the truck loaded with illegal cough syrup packets from owner of the vehicle, namely Mohammed Anas, aged so and so. And as per his instructions, they left Moradabad for Kuch Bihar about 4 days for clandestine disposal of illegal cough syrup packets to 2 persons, namely Babu Rahman, and Saiful Haq, alias Bapi at Dinhata. Purchases. But their names have not been there in the 161. Hindi version. Memo of evidence, my lord. My lord. After that, they have not done anything, my lord. After that 161, they have not done anything, my lord. Yes, my lord. Yes, my lord. Yes, my lord. My lord, since charge sheet is pending, my lord, let the IO be given an opportunity. Yes, my lord. Memo of evidence, my lord. Reflection. Yes, my lord.
I wanted, where is the document?
It's not in the very.
Take it out of the memo of evidence. None of the statement has done. Statement of the driver, how can you put it down? There is nothing, the statement does not. How the police.
Yes, my lord. That is what that is why.
We have not displayed. If you give me an opportunity,
I will. Yes, many persons, my lord. After that,
Get them arrested.
my lord, can you keep this matter on Thursday? My lord, can you keep this matter on Thursday, my lord? I need to ask the IO.
Yeah, but after this event.
Lordship, my lord. Grateful.
Item 36, your lordship, Miss Shumon Shehanub is appearing in this matter, but due to some of her personal difficulties, she had to leave, your lordship. I'm praying for next circuit. Shumon Shehanub, your lordship. She is the conducting counsel of this matter, your lordship. Grateful, your lordship. Same prayer, your lordship. Grateful, your lordships.
Lordship, I am for the petitioner. Lordship, allegation under section 376 G109 of the IPC, Lordship. Lordship, I am the friend of the principal accused. Lordship, in the FIR, nothing has been alleged against me to commit rape, Lordship. Only allegation is that only to the extent of helping the principal accused, Lordship. Lordship, helping means this against this petitioner alleged that he took photos, Lordship. Lordship, other co-accused person, but no such ingredient has been recovered, Lordship. That is the only allegation, Lordship. Other co-accused person already granted bail, Lordship.
You are coming and saying, my friend has committed
Lordship, charge sheet is submitted, Lordship. Lordship, from Lordship, FIR lost after 14 days, Lordship. There was a delay. Lordship, actual fact is that the principal accused and the victim lady have love relationship. And now the principal accused broke up. That's why this allegation has been made against them, Lordship. Thereafter, and also this petitioner's name has been added, Lordship. And from the Alice date of incident, there was 14 days delay, Lordship. And two other co-accused person already granted bail. One is granted bail by the learned honorable coordinate bench of this honorable court, Lordship, and another was granted bail by the learned court below.
164 of the victim girl Shukla at page 32. And the present petitioner is the FIR.
Lordship, as far as I know, Lordship, no examination has been done.
Took photograph with mobile.
No medical examination has been done as per my instruction, Lordship. Bail, Lordship. By the Lordship. Lordship, there are so many latches. Lordship, there were so many latches. Lordship, 14 days delay. Lordship, the medical examination not done. Other two co-accused person granted bail. Charge sheet submitted, Lordship.
Page 43 and 44, other 161 statement of neighboring.
Kindly consider the charge sheet submitted.
Yes,
Lordship,
but you get at page 39.
Lordship, major lady, Lordship, moreover. Lordship.
And therefore, on the ground of that, we expected the benefit of the hearings. That the state opposes the benefit that the goal of the government cannot be moved up.
Another piece of the thinking by the prisoner that there was a delay in the we have seen the and find that there has been an explanation of what is the medical report from the is reflective of but as all these are from even if have not have no active role committing a sexual assault, but taken on a basis and even captured that unfortunately that continues. And therefore, we do not think that there is the benefit of providence again and the full country.
I am grateful to your lordship. Grateful lordship.
For the petitioner, my lord. In this case, lordship, I will say that one day accommodation. My lord, one indulgence I am seeking. So for the case is 399,402. And the statement of the co-accused, my name transpired. That is mentioned in the page number 9, paragraph number 4. And from the bottom side, line number 7. The case was initiated in the month of 2023, August. He was not present, so for the allegation is concerned, his name transpired from the persons who were allegedly arrested from PO. That is my lord. My lord, one indulgence I am seeking. So for this. Several cases has been registered against that petitioner, your lordships. And he could, at the times wanted, he will collect all the details about the Shahjahan. And he is not the innocent person, your lordships. I just want the accommodations. Yes, lordships.
Lordship, this is second application, Lordship. Earlier application was just nobody appeared, Lordship. Lordship, this case under section 498, 325, 326, and husband, Lordship.
Principal accused husband.
Lordship, kindly please page number 9, Lordship. The FR, the incident of dated 5th July 2023, Lordship. Page number 9, Lordship. Yes, Lordship. Lordship, I apologize, Lordship. But with Pilo, Lordship, there's a computer printing mistake, Lordship. Yeah, brother. Pilo, Lordship. Yes, Lordship.
I'm taking my own time.
Page number 9, Lordship, the FIR, Lordship.
My lord, column number 3, your lordship. Sorry. But column number, my lord, item number 3, the article seized. The burnt sari, my lord. My lord, page 22 is the 164 statement of the victim de facto. My lord, page 22 is the 164 statement of the victim. কোথাও তো বলে নাই। Lordship, the story not believable, Lordship. The story, Lordship, alleged in the incident, Lordship, not believable, Lordship. Not believable, Lordship. Lordship, thrice attempt, but Lordship, not a single injury, Lordship. Yes, Lordship, first pillow, second burn, and last try to assault by sword, Lordship. But Lordship, cooperate with the investigation, Lordship. Any condition, Lordship.
Lordship, only attract the section 307, Lordship, this false allegation was leveled, Lordship. Lordship, Shari burned, but Lordship, no injury was received by the victim girl, Lordship. No injury was received, Lordship. No, no. Investigation.
or
Lordship, any condition, Lordship. So any condition, Lordship, cooperate with the investigation, Lordship. August 2021. 21, Lordship, 21. Deeply up.
Well, investigation is pending a lot.
This is the ritual. This is the ritual. Actually, it has to be on the left hand.
Left hand, and down on the detail. Down on the detail. Right hand. Baap jaya. Inje me kuch কথা বলিস না উনি রং ব্যাগ তাহলে সঙ্গে কথা বলে নিজে কোন নিজে কোন ভাই পার্টি চোখা ইনভলভ না নিজে ভুলে গেছে কি করছে আমার ডান ফটো This case relates to 498, 325, 326, 325, 326, and 34. I am the unfortunate husband who my lord. Actually, my lord, my marriage was ceremonialized. My marriage was ceremonialized long ago. Even one of our daughter already married. One of our daughter already married. And this affair was lost by my younger daughter.
Yes, it's
I am
very
very,
unfortunate.
I am very
He also
clear.
very young.
I may be permitted to take a.
No, you are saying that.
Actually, my sister lost the complaint. Younger daughter. Younger daughter lost this complaint against myself and other co-villagers. Against, including myself as the husband of the mother. Lost complaint against the father and the co-villagers. And so far the co-villagers are concerned, all of them except petition number 2 got the privilege of pre-arrest bail by the learned session judge could be had. And so far the petition number 1 is concerned that he is the husband of the alleged victim, and the petition number 2 is concerned is the co-villager. She is college going. Younger one, college going. 11 already 25 plus. So for my knowledge. But marriage was ceremonialized, I think, so far my knowledge goes 27 years back. And there was an explanation of delay also by the lost by the complainant. And that maybe my lord, counter view, subject to your lordship's correction, counter view also be possible.
Yes.
One indulgence may I seek. If we assume the entire story is right, I personally arranged the marriage of my elder sister, daughter. I also provide as much as possible from my end to continue her higher studies of my younger sister also.
Duties.
Bounden duties. Bounden duty, I am following. That is my bounden duty. Now, and for that reason, I'm just saying, if your lordship.
If your lordship kindly raise the voice.
Actually, my lord, so far my instruction goes, no such incident ever took place. Some hot altercation took place.
Why? Unexpected that the daughter will stand against the father.
when the father is such a responsible person who provides all kinds of support to the.
As per his best.
You go study whatever the expenditures which are required and ready to bear. Give the daughter to stand in the father.
No, my lord.
It's the normal and important way.
No, my lord. Now, my lord, my instruction goes at the relevant date and time. One hot altercation they took between couples. And on, as the petitioner is also an aged person, pushed her wife. He fell on the earth. Subsequently, people gathered there and there may be every chance. The daughter also not fulfilling the demand, lost this company. That probability cannot be ruled out. What? My daughter demanded something. I was against that. Because so far my instruction goes, which I am submitting, that is my instruction. Madam. She was in relationship with anyone else. I raised voice. And over that issue, hot altercation took place between her parents. At the relevant time, I pushed her mother and she fell on the earth. That is the instruction I have received. Mother. In a man of middle class society, at this stage also, subject to your lordship's correction, the parents are arranged marriage.
No, by God, that's why I have repeated some points.
Mother. Discretion.
Order upon this aspect, that why would you respect the as a mentor, you can act as a guide, as a father, what I
Well,
as a friend also.
Actually, in my view, so for my instruction says the father refrained her daughter for mixing with that boy, but her mother with her. That is the basic problem on the relevant date and time. It is not a case that she never received any injury. No, obviously. That should not be. That should not be. That should not. That's now I humbly submit was the actual scenario of this case.
The Lord, actual scenario is that
Now he is at about 55 plus.
have you finished? Have you completed your submission?
What's the second now?
Your allegation मेरे ऊपर जा रखा है. You have an external illicit relation with another lady, and when they protested, then you assaulted them. The basis of that complaint, the case was initiated. An FSC case has been initiated. But actual fact is that if your lordship kindly gone through the FI, nothing. He has a, yes. And when they protested, they were assaulted. Not only assaulted, they evicted from the house of
It
them.
is better to take, but better to follow a man who is going to be 60 and has an illicit relationship with anyone else. It is better to take, but better to swallow. Subject your losses. I am going to be 60. After the age of near about 60, I am going to pick up a illicit relationship with anyone else.
This is the high time.
Yeah, not 63.
This is the high time age. Yes.
So far the case number 2 is concerned, he is not a relative.
164 is there, my lord.
He is not a relative, he is a co-villager. 490.
Your lordship. Investigation is there. Investigation is there. The commit. Motive is that they evict from their house. They're trying to evict.
Number 2.
He's a good friend of. Can you proceed? No, I will come.
My lord.
I'm grateful, Your Lordship.
My lord, on 330 matter was there regarding the.
Item number 31, while your lordship was to ask the IO to produce the medical report.
No, original.
The complaint was lodged on 15th of December. But the FIR was registered on 20.
No. Kindly see the content.
Complaint.
Kindly see the content.
Complaint, date of complaint.
Date of complaint, wait, 25th, 15th.
25th person. No, 15th.
When the FIR was started, case was started. 25th. Case was started on 25th. They are the in-laws, my lord.
Learned Counsel representing the petitioners has submits that the instant petitioners are praying for anticipatory bail under section 438 of the Criminal Procedure Code. In support of his contention, the Learned Counsel submits that the complaint has been dated 25th December 2023. And the Learned Counsel brings to the notice of this court that in the said FIR, it has been categorically mentioned that on 24th December 24th December 2023 at about 10:30 a.m. the de facto complainant has stated to have gone to her in-laws' house where she
has claimed she has alleged to have been assaulted by these petitioners and her husband. Full stop. Learned Counsel further submits that in the FIR, it has also been mentioned that an emergency ticket, a Xerox copy of a Xerox copy of an emergency ticket issued by the Jalpaiguri Government Medical College and Hospital dated 14 date গুলো কিন্তু vital, date গুলো কিন্তু vital, ঠিক আছে, date গুলো ঠিক হয়েছে, dated 14/12/2023 has been annexed thereto. He further submits that the injury report is dated 25th of December 2023 and not 14th of December 2023, as has been mentioned in the FIR. Banking upon this discrepancy, the Learned Counsel seeks anticipatory bail. Full stop. The Learned Counsel, representing the de facto complainant, submits that the de facto complainant sustained injury and was admitted in the district hospital, medical college and Jalpaiguri Government Medical College and Hospital, and had to be treated there. Relying upon this contention, he opposes the prayer for bail.
Minor daughter of the in custody of the petitioner, and you have said that the earlier husband's father, now the petitioner. Because something was before they have not said that father confined their daughter. Now they are saying that we are confined at your daughter.
The Learned Counsel, appearing representing the de facto complainant, has also raised the issue that a minor daughter of the de facto complainant has been kept in custody of her father, and the de facto complainant has not been allowed to see the said minor daughter. এইটা আগে চলে আসবে, তারপরে এটা opposes the prayer for bail. ঠিক আছে? The Learned Counsel, representing the state, what the state has to say? Say, Learned Counsel representing the state opposes the prayer for bail. Full stop. Ongoing through the case diary, including specifically the injury report, which has been which has been furnished today.
Which has been fine place. Which was part of the record. Produced before us.
Including the injury report, which has been placed before us, it reveals that the said injury report issued by the medical officer of Jalpaiguri Medical College and Hospital from the injury report, it transpires. From the injury report, it transpires, issued by, it transpires that the date of the date has been mentioned as 25th of December 2023, while the FIR is said, FIR reveals that the incident is said to have occurred. The incident is said to have occurred at 10:30, at about 10:30 a.m. on 24th of December 2023. Full stop. From the injury report, it also reveals that there are bruises on the right upper thigh, which does not corroborate the fact of the ingredients of section 307 of the Indian Penal Code. Considering the aforementioned discrepancies, which is revealing from the FIR and the injury report, this court is of the view that the petitioners Subhash Chandra Roy, that is the father-in-law, Jayanti Roy, mother-in-law, and Neel Kamal Roy, the elder brother-in-law of the de facto complainant, may be granted anticipatory bail, full stop, in the event of arrest. They be released on bail, subject to 10,000 rupees, bond of 10,000, with two sureties of rupees 5,000 each.
10,000 each.
One you
One must be local.
instead of local, the extra state may be allowed.
Must be local, or apart from 438 two conditions, another condition that will meet the investigating officer once in fortnight. Arresting officer.
May I get one indulgence?
No.
Arresting officer. Surrender. ACJ.
That is CDM job. The local may be modified, because they are poor people only depends upon cultivation, and local may be modified.
Local.
No, the own land they cannot give him for security. And other persons are not eager to give their plots to their good person.
Yes.
One of the petitioner is a female.
Only you, petition number 2 will meet the IO as and when called.
Obliged.
We are not saying anything against your investigating officer, but we are not happy the way he is conducting the case or the investigation. We could have said many things, but we do not. This time we spared him. Henceforth, it should not. Should be very vigilant. Yes. Somebody was mentioning some matter. Which matter?
Two hundred and 46, my lord. My lord, partially, your lordship had heard this matter on Friday and posted this matter today, my lord. My lord, the difficulty is the trial court has fixed the matter today at 4:30 p.m. My lord, yes, yes. My lord, as I have filed this appeal, I have not given my blood sample, my lord. I am waiting for this honorable court to take up the matter and for DNA test. And meanwhile, my lord, they have. My lord, meanwhile, the state has preferred a cancellation of my anticipatory bail in the trial court. That application is pending. So if your lordship, if your time is also, my lord, today not permitting, tomorrow, my lord, if it can be fixed, my lord, at least we can intimate the learned trial court that the matter will be taken up tomorrow. My lord, if my lord, the state says, since I am not cooperating, I am not giving the blood sample. Yeah, with this, yes. Police inaction. With respect to my case, I was the de facto complainant in the case, my lord, I preferred the writ petition. Another case in which I am the accused person, that case was, my lord, brought into. And my lord, the honorable, my lord, at least, my lord, because. Lord, in that event, Lord, kindly fix the matter tomorrow, Lord. We will inform the learned trial court this matter. No, my lord. In that case, my lord, I have been directed to give my blood sample. My lord, pursuant to the order passed by the honorable single bench. Yes, my lord. Justice Keha's judgment, my lord, I am not holding now, right now. DNA, yes. There are many judgments, my lord. Yes. My lord.
Because I have seen that I shall inform. Tomorrow.